Good evening. My name is Sharon Wyatt, and I work with the Civic, Cultural, and Literary Engagement Team in the Adult Services Department of the Chicago Public Library. We are pleased to welcome you to our Law at the Library program. This program is one of the live events hosted by the Chicago Public Library and Evanston Public Library as part of their Law at the Library series. We aim to assist patrons in comprehending the intricate nature of legal information by offering lectures from reputable experts on legal topics and providing answers to their queries. The Chicago Bar Association is presenting this program, and we want to thank them for giving them their time to educate the public on this vital issue. We are delighted to have Carrie R. Peck from Peck Ritchie LLC as our guest speaker on the topic of wills, trust, and estate planning. Following the presentation, we will be opening to inquiries from the audience. Therefore, we kindly ask you to input comments and questions in the designated question and answer section. So let us extend a warm welcome to Mr. Kerry Peck.
Thank you, Sharon. Appreciate it. Good evening, ladies and gentlemen. Thanks for taking time to join us tonight. My name is Kerry Peck. I lead the law firm of Peck Ritchie, and we focus our planning on all of the issues, our practice on all the issues that relate to estate planning and basically getting old. We're all getting old, and some people today call us elder law attorneys. Some people call us trust and estate attorneys, but we do estate planning, and we also do the courtroom work that relates to disputes involving wills and trusts and whether mom was cognitively impaired at the time she did her will or she understood what she was doing. So I want to thank the Chicago Bar Association and the Chicago Public Library and the Evanston Library System for hosting us tonight, and encourage you to ask questions along the way, so that when you get off this Zoom, you can turn to your family and friends and say, I attended an educational program and this is what I learned. So tonight, as Sharon indicated, we're going to talk about planning ahead, wills, trusts, and estate planning. And we're going to open the presentation tonight with a hypothetical that will illustrate some of the problems that we're going to discuss tonight. So our hypothetical, which I'm going to read, indicates that James is a successful businessman with a growing company by the age of 30. So he did pretty well. Mia, James' girlfriend, has been by his side since they were teenagers and helped him get his business off the ground. While the two have never been married, they do have a 3-year-old daughter, Emily, and they recently purchased their first home together. James and Mia have always lived in the here and now, and with getting the business off the ground, they never much focused on planning for the future. Besides, they were both so young and barely had any money until the recent success of the business. One evening, the unthinkable happened. James was riding his motorcycle home from work and was involved in an accident with a distracted driver. The driver of the vehicle that hit James walked away from the scene uninjured, but unfortunately, James died right at the scene. Mia and James' family were devastated at his untimely passing. He was still so young, had so much life to live, a business to keep growing, and a family to support. How could this happen? Prior to his passing, James had not gotten around to completing any estate planning. He always wanted to make sure Mia and Emily were taken care of, but getting it done always ended up on the back burner. He thought the money to pay for the planning would be better put to use on growing the business, fixing up the new house, and meeting the daily needs of progressing with life. Mia hires a probate attorney to begin settling James' estate. When she finds out that his parents have already begun the process, seeking to administer his estate themselves. So let's take a look at this problem right from the get-go. Ladies and gentlemen, despite the fact that James and Mia were together much of their adult life as a couple, and they have a child, and they have a house, there's no provision under Illinois law for James to have died and to leave his unmarried girlfriend anything. James's estate passes in what we call intestate succession, which means without a will. Under the without a will provisions of Illinois law, Emily, the child, will inherit some money. But the reality here is Mia, who survives James and is the mother of the child, gets nothing. And the reality is that James's parents are going to have preference over Mia to administer James' estate. And a post-death probate estate is necessary in Illinois when an individual dies with over $100,000 in assets. Those assets can be a composition of anything. It can be cash, it could be real estate, it could be a stock portfolio. If it exceeds $100,000, a post-death probate proceeding is necessary. And that post-death probate proceeding is a court proceeding opened in the county in which James died a resident of. That proceeding gathers the assets, pays the debts, and distributes the property according to the laws, again, of what we call descent and distribution or intestate succession. Same terminology. There's no will here, and James regrettably didn't plan ahead. So let's take a look at the next slide, in which we find out, why do people wait? Why don't people get their estate planning done? So if you don't have a will, what would motivate you to get one? Well, on the caring.com website, 41% of the people that responded said a medical diagnosis or health concern would motivate them to get a will. 16% said a death of a loved one would motivate them to get a will. 20% said family expansion. Could be a new child, a new marriage. 22% said a purchase of a home. 21% said retirement or other age milestone. 14% if the employer pays for it as an employer benefit. And 24% of the people that responded said nothing would motivate me to do a will. Nothing would motivate me to do a will. Well, the hypothetical that we've created should motivate everybody watching this program tonight to get their estate planning done. So when we look at the next slide, the question is, what is estate planning? Why do we do it? We do estate planning in large measure to distribute our assets after we die. We also do our estate planning to plan in advance for the management of our financial affairs in the event we become mentally incapacitated. Example, someone has a stroke. Many strokes affect an individual's cognitive ability. If you have a stroke and you don't have a will, the question is, do you still retain the mental capacity to do a will? We also do advanced planning in the context of a will or powers of attorney to plan for healthcare decision-making. In Illinois, we'll talk about it in a much greater detail as our program progresses. We have two types of powers of attorney. One is a power of attorney for property, which is management of assets. Property is a generic term, doesn't mean exclusively real estate. And we have a power of attorney for healthcare. Clearly in the title, you know what that's about. What is a power of attorney? I name Sharon to make decisions for me when I'm not capable of making them myself. In addition, we do estate planning to do asset protection. We do estate planning to reduce taxes. Illinois has a death tax imposed on individuals that have assets in excess of $4 million. And we do it to avoid probate. Again, in Illinois, if you die with over 100,000 in assets in your name alone, you're going to be required by your surviving family to open what's called a decedent's estate, a dead person's probate. Probate will be open not less than 6 months and could be open considerably longer. We'll talk about it as we proceed. So, what's our goal for estate planning? Well, even before the estate taxes, the goal of estate planning was to protect assets from creditors if we can. Just because you have a will doesn't mean you're protecting assets from creditors. You need to do more sophisticated planning. You want to perhaps preserve family wealth for future generations. You want to provide support and income for the family under all the circumstances, obviously the surviving member of the family. In our hypothetical, to Emily, the daughter, and to Mia, the girlfriend. No provisions for any income to those folks. We want to manage assets for people who can't manage it themselves. They have a stroke, they have a car accident, they have a heart attack that affects their cognitive ability. Planning will be the answer. Or, in our hypothetical, James owned a business. He did no business succession planning. Who inherits James' business? Well, who did he want to leave it to? He might have wanted to leave it to Mia, but he made no provisions for Mia, and he made no provisions for Emily, his longtime girlfriend, who helped him create the business. So what can you expect from an estate plan? Well, a nominal estate would focus on who will manage your assets for your benefit during your lifetime if you should become disabled and unable to manage your assets. Under what circumstances it would make sense to distribute your assets during your lifetime. And how and by whom would your personal care and health care decisions be made during your lifetime if you're not able to make those own decisions? How will your assets be distributed after your death? And will you name a guardian of any minor children? Who will be that guardian? A larger estate would address tax planning issues and various methods of preserving the estate planning for the beneficiary's benefit. So, as we look at the next slide, we need to think about what's included in basic estate planning. And our photo up there on the right is the Doublemint twins. I'm sure some of you remember the old time commercials of the Doublemint gum and the Doublemint twins. And the reason we're using that on this slide is a power of attorney is a document in which you name your legal clone. You name your agent to manage your health care or manage your finances when you can't do it yourself during your lifetime. Power of attorney is a lifetime document. It's a legal document granting your agent, and under the terminology of a power of attorney, the person is naming an agent. They are called the principal, not of a school, but the principal in a power of attorney. I'm the principal. I name Sharon as my agent, hypothetically, to make decisions for me when I can't make them for myself. So a power of attorney is a legal document granting authority to someone else whom you trust to act for yourself in certain circumstances. You're naming your legal clone. That's why, again, we've got the Doublemint twins up there. One is the principal, one is the agent. In Illinois, in our next slide, we have a power of attorney for property. Again, the term property is generic. It is not exclusively for real estate. So keep that in mind. A power of attorney appoints an agent to make decisions for your financial issues should you become incapacitated. Now, most people never believe they're going to become incapacitated. So they go, all I need is a will. Carrie, I'm going to die. I need a will. Well, the reality is we're all going to die, but the vast majority of us, as we age, will be incapacitated at some point, unable to make our own decisions. And a power of attorney for property is the best way to avoid another court proceeding, what I call a lifetime probate. Remember, we've already talked about a post-death probate. A lifetime probate is a guardianship case. A guardianship case is a court proceeding open to determine, number one, does someone need a guardian? And number two, who should be that guardian? A guardian is an individual, a third-party decision maker appointed by the court to manage your affairs, both financial and healthcare, when you're not able to manage them yourselves, if you don't do powers of attorney. So you want to stay out of that courtroom if you can. You want to create powers of attorney. You want to consult an attorney, have a discussion, learn about these documents, avoid that lifetime probate if you can. It's expensive, it's emotional, and it's a full-time process until you die. If the court finds you need a guardian, that guardian is going to need to account for your assets, report to the court in accounting every year, file medical evaluations, and things of that nature. If you can, you want to avoid it. You can by planning in advance. So a power of attorney for property is useful, particularly as you can note in the center of that slide on the bullet points. Some assets cannot be owned in joint tenancy. Joint tenancy is two individuals own an asset, and one dies, it goes to the other. It avoids probate. It's a good device to use. IRAs, 401ks, we can't own in joint tenancy. So power of attorney for property is a good document to have. Powers of attorney for property, you can handle tax activities, you can establish various types of trusts, you can change the title to property, you can pay your bills, okay? An important, critically important document. Make sure the person you name agent under your power of attorney loves you more than they love your money. So I like to conduct these programs in an interactive fashion. If you have questions, let us know. Lauren, do we have a question?
We do. We actually have a couple, but this one is pretty timely. Lorena asks, is a spouse automatically given power of attorney?
No, absolutely not. There is no provision in the law. The only provision in the law that allows a spouse to act is in an emergency scenario in a hospital. The spouse can make medical decisions at that point. The spouse has no authority to pay bills, no authority to do tax returns, no authority to take care of the normal course of business. Unless they're already on the account, they can't withdraw money. Perhaps they can sign the tax return if they're married, certainly, and they've done that in the past. But no, you should absolutely get these documents in writing done. So as we move ahead, again, there's a second type of power of attorney, a power of attorney for health care. And a power of attorney for healthcare appoints an agent to make healthcare decisions on your behalf if you become incapacitated. Ladies, Lauren, Sharon, we've got, I'm blocking part of these slides. Can the folks at home see those slides without seeing us?
As far as I know, yes.
Okay, great.
You're clear.
Yes, okay, Sharon says yes too. Perfect. So a power of attorney for healthcare is again the second kind of power of attorney. And a power of attorney for healthcare speaks its name in the title. You name an agent, I'm the principal, I name an agent to make healthcare decisions for me. I want to make sure that I talk to that agent about what kind of healthcare decisions I want. Do I want life support at the end of my life? Do I want to be on machinery that can keep me alive with my heart pumping and breathing? Do I want to be kept alive at all costs? Or do I want to empower my agent to remove life support, ostensibly pull the plug? This is an important discussion that must occur with your agent. Do I want to be an organ donor? Do I have certain organs I don't want to donate? Do I want to donate my eyes? Do I not want to donate my heart? Do I want to donate my kidney? All of these discussions must occur with your agent because you want your agent to carry out your wishes when you can't carry them out for yourself.
Carrie, we have a few more questions. The first one is, if I name my cousin as my agent, can I also make him the beneficiary of my HSA? Precisely, can the agent also be the beneficiary in a power of attorney? I think we're getting confused on a couple of the terms there.
Yeah, we're kind of mixing and matching, but the answer is your agent can be a beneficiary of your assets. Okay, there's no problem there. Your agent cannot, let's assume that we're talking about an agent for power of attorney for property. Your agent cannot steal your money. Your agent has to account for their stewardship during their lifetime. How did your money, how was your money used? Much, you know, that's easier. So yes, you can name an agent, your nephew, your cousin, under a power of attorney. That person can be a beneficiary of your 401k, of your will, of your trust, as long as they don't breach their fiduciary duties. An agent has the duty of loyalty under the law. It's the highest level of duty owed to someone else is to be named an agent under a power of attorney. Lawyers are fiduciaries to their clients. Accountants are fiduciaries to their clients. So it's a very high level of duty and loyalty owed to the principal.
Okay, and then we have another question. What if these documents, estate planning documents, are made in Illinois, but in 10 years, the person moves to another state for the rest of their lives? I assume that the POA and very specific documents where an individual is named remain unaffected by the move. But in what situation would moving to a different state, other than where the documents are made, have an impact, if at all?
Well, we live in the United States. All documents are to be given what's called full faith and credit from state to state, which is a good thing. The next part of my commentary, though, is those documents should be reviewed by a local lawyer. If you're done in Illinois and you're moving to Florida, have them reviewed when you get to Florida. Make sure that they comply with the Florida law. They should be recognized, but our problem here is sometimes if you do a power of attorney in Illinois and you move to Arizona and Florida, and you have an emergency and you walk into the hospital and they say, do you have a power of attorney for your mother or your wife or your son? And everybody goes, yep, they're right here. And they go, okay, that's an Illinois power of attorney. We're not familiar with that document. We're going to have to talk to our lawyer about it. In the meantime, you had a circumstance hypothetically in which you had to make a snap decision in the emergency room on a medical procedure. You want to have a power of attorney that's recognizable by the people in the state where you live. Have it reviewed by a local lawyer.
Okay, does the 5 wishes document serve as a legal document for healthcare and medical wishes?
I don't believe it's legally recognizable. It's clearly in use in a lot of places. But my opinion is you should use what we call the statutory forms in the state that you're going to reside in. In Illinois, we have a statutory short form, power of attorney for healthcare, a statutory short form, power of attorney for property. The 5 wishes gives you a lot of different choices. You can amend the statutory form and add all of your choices, but I would not use the 5 wishes as your basic document. I think that's a mistake.
Perfect. We have someone looking, and I apologize, I was reading these questions. Someone was looking for a little bit more clarification on what the 5 wishes document is.
5 wishes is a document that people are encouraged to use and sign to convey, I think, more detail on their end of life decision making, their burial, their fundamentally, I would just say end of life and everything that goes along with it. It's a bit more faith oriented. It's got details on religious ceremonies, if you wish. It doesn't have to, but I don't believe it's a quote unquote legally recognizable document. It does convey your intentions, but it's not going to be accepted at a hospital as a power of attorney.
Okay. All right, we'll continue on. We have some questions that are more appropriate further down the line.
Okay, so on our next slide, we talk about a last will and testament. And I think it's important everybody understand power of attorney documents. I said this before, I'm saying it again on purpose. Power of attorney documents are lifetime documents. They die when you die. A last will and testament has no validity during your lifetime. My law firm constantly gets phone calls. Hi, my name is Jimmy. I'm executor. Executor means the person named under the will to manage the assets, pay the debts. I am executor for my uncle, and he won't do what I want. I want him to go into a nursing home. And I say to the caller, well, if your uncle's going to go into a nursing home, he's still alive. Johnny, you have no power whatsoever, named as executor under your uncle's will. Your uncle's will has no validity until he dies. Powers of attorney die with us. The last will and testament springs to life. Okay, so the last will and testament appoints an executor to manage your estate. It directs payment of debts, last expenses, and it directs the distribution of your estate after you die. A will is a public document. The law requires in Illinois that that document be filed in the in the county in which you die a resident of. I live in Cook County. I die a resident of Cook County. My executor has 30 days to file that will with the clerk of the circuit court of Cook County. Same applies in Lake County, Kane County, McHenry County, DuPage, Will, et cetera, okay? It is a public document. And it does not avoid the post-death probate proceeding that we talked about earlier. Again, the post-death probate proceeding, the fundamental issue you need to focus on is, do I own $100,000 in assets in my name alone? So I think there's a lot of confusion regarding wills. I think that there's a lot of confusion in this whole arena. There's a lot of what I call mythology. In high school, we all studied Greek mythology. This is kind of probate and trust and estate mythology. A lot of people believe certain things. Most of it is not true. Yes, Lauren.
Okay, we have a couple of questions, pretty similar in nature. One is, I would like to create a will without paying an attorney. Do you have any guidance to make sure that the will I create without a lawyer will be legally viable?
The answer is that I've been a lawyer now in the trust and estates world. I lecture on the subjects. I've written multiple books on the subjects. I teach lawyers. I teach classes like tonight. I've traveled around the country to teach lawyers for the National Academy of Elder Law Attorneys, the American Bar Association, the Chicago Bar Association, the Illinois State Bar Association. I was just asked yesterday to give a speech for the comptroller of the currency to bank regulators on these types of subjects. If you do a will yourself, you are making a big mistake. You will never know, but I'm here to tell you that I've never seen a self-done homegrown will work. They always fail. They always create litigation in the courtroom. You won't know it. You're deceased. There are some programs throughout the city and the Chicago metropolitan area that allows you to go to a clinic, a legal clinic, and get a will done for free. Do that if that's what you want to do. Chicago Bar Association, we participated for a long time, does, for example, what we call wills for heroes. And we do wills for firemen and policemen, first responders, without cost. So there are some programs out there. Don't do it yourself.
Along the same lines, Carrie, there's a question. There are many online options to create your own will. What's the difference between doing it yourself versus using an attorney to create your estate planning?
The difference is you didn't go to law school. The difference is you don't have a legal education. The difference is if you go to a lawyer who specializes in trust and estates and planning, they know what they're doing. They will make sure that you avoid the problems that I guarantee you will make by doing it yourself. It's just a serious mistake. And again, I can't emphasize enough, you'll never know. You will leave behind a terrible mess for your family, your friends, your loved ones, whoever you want to inherit your assets. It doesn't work, ladies and gentlemen. I've never seen it work. And I've seen a lot of what I'll call, again, homegrown wills. The websites that tell you fill in the blanks and so forth, they're in a business to make money. I would not recommend you do it.
We have another question for the will. Are you saying I need to have a will right now? Or can I wait to file one? I didn't know I needed to have one on file.
Okay, so there's a little confusion in that. Anybody over the age of 18 is authorized to have a will. Your will does not have to be filed until you are deceased, until you are dead. Your executor under your will is then obligated to file the will within 30 days. So there's no requirement during your lifetime you file a will. The requirement for filing is post-death. Let's move on, Laura. I'm sure we're going to have a lot of questions, but we got a lot of slides to get through. Our next slide focuses on what we call revocable living trusts. Revocable living trust is a document designed in large measure to avoid that post-death probate. Again, post-death probate, excess of 100,000 assets in your name alone. A revocable living trust recognized in all 50 states is a legal fiction. Why? Because we take our assets and we put it in a revocable living trust. So your revocable living trust, my revocable living trust says, Carrie Peck, trustee, important, you can retain control of the Carrie Peck Revocable Living Trust dated May 23rd, 2023. The document is used to avoid that post-death probate. The document is a private document. It can be amended. It can be changed as your life circumstances change. You have another grandchild, you want to put that grandchild in. You get remarried, you want to put your new spouse in. It's amendable, revocable, changeable throughout your entire life, as long as you maintain the mental capacity to change those documents. It also avoids that lifetime probate that we talked about, guardianship. Why? Because should you become unable to manage your affairs, you name a successor trustee. You name yourself trustee originally, you have a stroke, your daughter, your wife, your son is your successor trustee to manage your trust. So this device, this document, has lifetime benefits and post-death benefits. It allows for tax planning to avoid taxes. It doesn't allow asset protection for the person making it, but it does allow asset protection for the beneficiaries down the road. And it's an integral part of an estate plan. Today, most estate plans have 4 documents: power of attorney for healthcare, power of attorney for property, a revocable living trust, and what we call a pour-over will. And the title tells you assets not in your trust, pour over into your trust upon your demise. But again, it's important we keep those assets that are not in our trust below that $100,000 threshold to avoid that post-death probate. So I'm sure there are going to be some questions about this, and I want to make sure everybody on tonight's Zoom call and seminar understands that. Next slide is about irrevocable trusts. Okay, prior slide was revocable trusts. Irrevocable trusts are used in large measure to protect assets that can't be taken out later. They facilitate gifts, and it's most often used for life insurance policies as well as complex estate tax reduction. If someone, and it's also used for Medicaid planning, someone asks you to sign an irrevocable trust, your antennas should go up. Why am I being asked to sign an irrevocable trust? I'm not comfortable signing an irrevocable trust. Unless you're working with a competent, capable, reliable lawyer, you shouldn't be signing an irrevocable document. It's too dangerous. You have to go to court to change an irrevocable document. Contrast that with a revocable trust and change it in your lawyer's office. You do not have to go to court. It's amendable and changeable. Again, somebody wants you to sign an irrevocable trust, they better have an awfully good reason, and you better trust them an awful lot. Next slide, please. So I've talked a bit about probate. I want to make sure everybody understands. Probate is a court supervised process by which the representative, an executor if you have a will, an administrator is appointed if you don't have a will. That those persons' jobs, administrator, executor, to collect the deceased person's assets, pay the debts, and distribute the balance under either the will or under state law and by the applicable county procedures. Early on in the presentation, we talked about state law being administered in each county probate court. So people entitled to receive the estate are identified in the decedent's last valid will, or if not, under the state's intestate succession. Probate law is the primary law that lays the groundwork for settling estates. Next slide, please. So as I mentioned, each county has a probate court. Here in Cook County, the Daly Center has a probate court. The entire 18th floor of the Daly Center is probate judges. They hear probate cases involving guardianship. Is mom disabled during her life? And they hear cases involving decedents. Mom has passed. Now we need to open a probate estate because she didn't plan to avoid it. So probate court is also where family disputes occur. Many multiple marriages end up in probate litigation. Children from the first marriage sue the surviving spouse of the second marriage. Oh, my father didn't take care of me the way he promised me he was going to do. Multiple marriages often end up in litigation. So in the next slide, we look at the potential estate complications. Was the will properly executed? Was it forged? Was there fraud involved in getting it? Was there undue influence? Was the individual who created the will, okay, fancy term, testator, of sound mind and memory? Were they unduly influenced by one child who didn't tell his or her sisters or brothers, hey, I'm taking mom to my divorce lawyer to have her do a will, maybe a revocable living trust, leaving me everything. You guys get nothing. Okay? A clear case of undue influence. If creditors file claims, your credit cards, your funeral expenses, doctor bills, things of that nature, it goes into probate. If the executor or someone believes that assets belonging to the estate are not included in the estate, somebody has stolen money, a caregiver stole money from mom while she was in the nursing home, and she used it to buy a 2-flat building for herself, we file a citation to recover that asset into the estate. Breach of fiduciary duty, we talked earlier about loyalty, the highest level of loyalty under the law. Breach of fiduciary duty, an agent under power of attorney, executor under a will, a administrator under no will, but appointed by the court. All of these issues typically lead up to an accounting, an administrative accounting, the assets, the expenses of the estate submitted to the court for approval. Again, avoid this by using a revocable living trust. So let's take a look at Elvis's probate estate. Elvis, who's dead over 50 years, amassed a large sum of money, $10 million. He lost about $73 million in estate tax, probate process, and other settlement costs. His case illustrates why the best way to protect your estate is plan. Okay? You can see on the chart that Elvis started with 10 million and left his heirs less than $1 million because of estate taxes, administrative expenses, legal fees, executor fees, and debts of almost $4 million. Not a good scenario for Elvis's family at the time. So how do we avoid probate? One of the ways we avoid probate is we create joint tenancies. As I mentioned earlier, joint tenancy often used husband and wife. Husband and wife open a joint tenancy bank account, a very common ownership. Husband and wife own their home in joint tenancy. Gentlemen, unfortunately, we generally go first. Husband dies, the joint tenant asset, the bank account or the house, passes to the wife, the surviving joint tenant, without a probate estate. So joint tenancy is a great method of owning and avoiding probate. Now, here's the problem with joint tenancy. If you create a joint tenancy with one of your children, let's assume that your spouse is now deceased, your joint tenant child gets divorced, their opposing spouse is likely to try and grab that asset into the divorce. Joint tenancy also may unintentionally disinherit other people. Mom puts one child on the checking account after dad dies to help pay the bills. Mom and dad had 3 kids. Mom dies. The joint tenant on the account gets the asset and says, Mom wanted me to have it. I'm sorry to my sister and my brother, you don't get it. So the other thing in joint tenancy, you need to be aware, a joint tenant has 100% invasion rights of that account. So if I own a joint tenancy account with my wife, of course, I can take all the money. I own it with my child can take all the money. If I decide to put another loved one or a stranger on my joint tenancy account, I'm going to lose all my money to that stranger who's going to steal it. Okay? Because 100% invasion rights. As we talked earlier, the other method of avoiding probate is the use of a revocable living trust. Moving ahead, we're going to take a look now at mistakes of the rich and famous in estate planning. In our first discussion, Chadwick Boseman, best known for his role in the Marvel film Black Panther, died at the age of 43 of colon cancer. He had no planning whatsoever. Boseman's wife petitioned the court to split his estate 50% to the wife, 50% to the parents. Ultimately, that estate lost 1/3 of the assets for the expenses that are listed in the bullet point at the bottom. Moving to the next slide. Heath Ledger. You know Heath Ledger from a variety of movies. The Dark Knight, the Batman movie, I think perhaps is the most famous. There are others. He died at the age of 28 of an accidental overdose. His will was executed in 2003 with 50% of his estate going to his siblings, 50% of his estate going to his parents. What happened? Mr. Ledger had a child born in 2005. She was not provided for in the will. Fortunately, Ledger's parents and siblings gave an inheritance to the daughter. They didn't have to. The law didn't require it. There's an awful lot of cases in which people leave their estate planning incomplete because they have children after it's done and the children don't inherit. Thank you, Sharon. The next rich and famous is Amy Winehouse. Amy Winehouse is a troubled British soul singer. Got a lot of hits up there. At the age of 27, she dies of alcohol poisoning. Unmarried without a will, so her estate went to her parents. 2019, her ex-husband, for 2 years, files a claim saying he was entitled to money because he was married to her at the time of her success. Well, guess what? He was awarded a cash settlement at the time of their divorce and goes without anything other than the parents have to defend that claim in probate court. And they did. Next slide, Sonny Bono. Sonny has no estate planning. Sonny loves wedding cake and gets married to his 4th wife. Cher files a lawsuit against the estate for approximately $1.6 million he didn't pay during their 1975 divorce. You may recall, Sonny hits a tree skiing down a hill. Leaves behind a wife, 4th wife, 4 children, and approximately $2 million. In addition, A man files a lawsuit against Sonny's estate claiming he was a love child. Ultimately, his case is dropped when he's asked to provide a DNA. He can't do it. The estate is ultimately divided between his wife and his children after they fend off and defend the claim of share, the claim of the love child, and so forth. Next one, James Gandolfini. Everybody remembers this gentleman from The Sopranos. The age of 51, his success was stunning. He accumulated $70 million because he did no planning, poor planning, if any. He lost $30 million in estate taxes. Outrageous. All he had to do was plan and reduce the tax burden. So let's address the obvious. Death is typically not a comfortable conversation for any of us. But it's essential if you want to save your loved one's heartache and frustration to get your documents done right. And when you get your documents done, tell your loved ones where they are. In Illinois, you do a will and it can't be found after you die, it's presumed revoked, assuming you had possession of that document. So what's our key takeaways tonight? You don't have to be rich or famous to need estate planning. No matter the size of your estate, proper planning is important. Mistakes can turn costly, potentially in a public courtroom process. As you review the documents, maybe you have them already. Does your current will and current trust match your current wishes? Again, our relationships in life change. As your circumstances in life change and your relationships change, your documents need to be changed. Are your assets titled correctly? Do you want them in joint tenancy? Do you want them in a trust? If you put them in a trust, have you funded your trust? Meaning, have you changed the asset title? And are you still comfortable with the person you named as agent under your power of attorney for health care, to make your decisions, your end of life decisions, or the management of your assets? Life changes. Statistics show us in the studies that show us that we change our social structure, our friends, virtually every 7 years. We have a new set of friends. Now, clearly that's not for everybody. Some of us have friends. I have friends from grammar school, but very few. Most of our friends come and go during lifetime. And if you've named friends, you want to make sure whether you name them to receive money or you put them in charge, that you still want to do that. Lauren, so finally, before we go to questions and run out of time, I want to say thank you very much. I appreciate the opportunity to appear with you tonight. We at Peck Ritchie offer you a free initial consultation. We use what we call a personal concierge approach. We are recognized leaders here in Chicago and throughout the Midwest, virtually the entire country. We've served in leadership positions throughout the country. The Illinois Supreme Court last spring named me to chair the first statewide elder law commission to address the tough issues involved in elder law, including what lawyers have capacity. How do we determine if lawyers have the capacity to continue the practice of law? We're happy to meet with you in our suburban offices, northern suburbs in Northbrook, western suburbs in Oak Brook, or at our downtown office in the financial district. And we look forward to working with you, whether that's in the courtroom, out of the courtroom, planning your estate, or defending your estate from challenges that would be inappropriate. Lauren, questions?
Okay. If all beneficiaries agree to distribute a trust's assets differently than written, is that okay?
It can happen, but the law requires that we engage in typically, if it's not in a courtroom, a non-judicial settlement agreement in conjunction with that trust. So you're going to need a lawyer to help you navigate through that.
Okay.
It
If
can
you're
be done.
If you're divorced and do not want your only adult child to inherit any of your assets, including a 401k, what is the first thing that you should do apart from not naming them as a beneficiary?
Well, clearly you're right. You're dead on. First of all, in Illinois, you can disinherit anyone but your spouse. So you're divorced and you don't want to name your adult child, name somebody else the beneficiary. I would suggest you do a will that says specifically, I disinherit my son, John Doe. So that it's very clear what your intentions are. So ultimately, John doesn't attack the 401k beneficiary and say you unduly influence my mother. That's what I would suggest you do.
How does the revocable living trust avoid estate taxes?
Revocable living trust does not avoid estate taxes, but use of a revocable living trust can pass the estate tax burden to the second spouse to die. So you can delay payment of those taxes to the second spouse with specific language in the trust.
Can it be more than 100,000 in one bank, but only 100,000 in each account at the same bank?
No, the combination of 100,000 in multiple accounts, multiple banks, does not avoid the $100,000 threshold. So if you have a bank account at the Northern and at the Citibank and at Chase and at Fifth Third, they reach 100,000, you've not accomplished the avoidance of probate.
Okay. So you have 30 days to file a will with the county. Do you have a similar obligation to file the trust, or does the non-public nature of the trust mean that you don't have to file it?
100% accurate. Question is dead on right. You do not have to file a trust. Trust administration occurs in the privacy of our law firm conference room, not in the courthouse.
What review or oversight is there of a successor trustee of a revocable trust to prevent the mismanagement or possible embezzlement of an estate settlement if the trust is a private document?
It's a great question. There is no oversight until ultimately that individual dies. Use of a successor trustee is either on disability or death, and the beneficiaries would have the right then to engage in oversight of the successor trustee's stewardship of that trust. It could be too late. You're talking about embezzlement. That successor trustee could steal that money. Okay. You want to make sure that you've got your lawyer involved in taking a look and making sure that they're engaged to assist that successor trustee in the management of that trust. And that lawyer is going to have some oversight in terms of, is that successor trustee stealing that money? There is no court oversight.
Can anyone, regardless of citizenship, set up a power of attorney?
Yes. You need to be a resident of Illinois.
Do beneficiary designations override the will?
Yes.
Say I procrastinate on everything. Can I write a short paragraph on my email and send it to people before I die? And that can then be used as a legal document as either a trust or a will?
Unequivocally, no, it won't work whatsoever. The execution of a will requires, in accordance with Illinois law, 2 witnesses to attest, sign their name and attest that you are of sound mind and memory at the time you sign. Most people also put a 3rd witness in as a notary.
Are lawyers named as executors for wills, or who is typically named as executors? Spouses, children?
Lawyers can be named, or spouses and children can be named.
Can an executor not accept the role What if becoming the executor is a total surprise to someone and it's not a good situation? Does a will obligate an executor, or is there a way out?
There's a way out. The executor resigns. Most wills would have a successor executor named. If there's no successor and the will needs to be probated, the court will appoint an administrator, fancy terminology, with the will annexed. So yes, the executor can resign.
If the only major asset is the house, can I use a land trust instead of a revocable living trust?
Yes, and that'll avoid probate.
Did you say the 30 days to file a will, is that after the person has died? And is it in the county you died, or where the will was executed?
30 days post-death, after death, and it's filed in the county in which you die, not where it's executed.
All right. Is it true that a successor trustee of a revocable trust can automatically assume financial power of attorney duties if the trustee becomes incapacitated, and therefore that a separate financial power of attorney document need not have been previously prepared and issued?
It's a confusing question because we're kind of mixing two documents. The successor trustee will take over and administer the assets that are in the trust. But there are assets that will be outside of the trust. For example, that 401k. You can't put a 401k in the trust. So you're going to want to have somebody be named agent. And to directly respond, the successor trustee does not assume the role of agent under a power of attorney for property.
Okay. How does one find a law group which deals in elder law?
You can go on I would urge you to consider taking a look at what professional organizations or lawyers affiliated with were active in what's called the National Academy of Elder Law Attorneys. They have a search system on their database. The Chicago Bar Association makes referrals. But I think you want to go, you can go on a lawyer's website and see what he or she has done in the community and what they've talked about, what they've written about. You want to find somebody who is in the arena you want. An example, here's a book the American Bar Association asked me to write called Don't Let Dementia Steal Everything. Okay, so you want to find a lawyer that knows what they're doing in your arena. Today, everybody relies on the internet to do that. I would suggest you rely also heavier on word of mouth. How do you choose a doctor? You ask your neighbors, you ask your friends, you ask people that need a professional. You don't want to go to a podiatrist for a heart problem. Same way you don't want to go to a generalist or a criminal lawyer to write your will. So look at what's on the internet, but at the same time, talk to your friends, your neighbors, your loved ones, and get a recommendation.
There's a couple of questions asking generally about cost to create an estate plan.
At my law firm, we sit down with you, we discuss who owns what, how it's owned. We want to get a perspective on what it is you're asking us to do. Once we know what services we are being asked to provide or recommend to you, we will give you a fee quote and we will put it in writing. Get your fees quotes, get your agreements with lawyers in writing. Okay, and the fees range from nominal to expensive based upon the complexity of the situation. And we don't discuss fees in a vacuum. We don't know what we're going to do. We'll be happy to tell you what our fees are when we know what we're going to do. And we're in a complete transparency, and again, in print. It's not going to change.
Okay. I have 2 adult children, one of which is not self-sufficient, so I've set up a special needs trust for him. I currently have his sibling as the trustee of this trust. My question is, do I need to set up a trust protector for his trust, or is it sufficient to have my daughter as trustee with no trust protector?
Well, the trust protector is a pretty specific scenario. The facts of your case depend on the dynamics of the family, quite bluntly. And I don't think we can answer that in the context of a question of kind of this program, but you certainly, you clearly have some knowledge on the subject. I don't know the dynamics. I don't really know what's going on. A lot of people use just a trustee, and a lot of people put in a trust protector. So it's kind of 6 of one, half a dozen of the other. We need to talk about it in greater detail.
If in the will, I have disinherited my adult child, but in my 401k, he's the beneficiary, does the will override the 401k?
It does not. A 401k beneficiary is going to override the will. If that's what you have, you don't want it. That will should be revoked. Otherwise, you're just creating problems for everybody once you're gone. And I think Sharon's joining us to tell us, ladies and gentlemen, we are out of time. It's been a wonderful program. I thank you very much for joining us. I'm told we have over 200 people tonight. And kudos to the Chicago Public Library and the Evanston Library and the Chicago Bar Association. And again, if we can help you, please reach out to us. And we look forward to working with you. And we look forward to doing another program as the Chicago Bar and the library systems dictate. Thank you very much. Have a wonderful evening. Be safe out there.
Everyone, we have reached the end of this evening's program. The recording of this program will be available on the Evanston Public Library's YouTube page. I want to thank Mr. Peck and Lauren for the enlightening presentation. Additionally, I appreciate the Chicago Bar Association for organizing this event. We offer monthly Law at the Library seminars via Zoom, covering various legal topics. Please spread the word to your connections, and please feel free to sign up for additional Law at the Library sessions through the Chicago Public Library website. Have a good night and stay safe.